Hello and welcome to the July 2021 episode of My PIP Monthly. My name is Amber Ross Holloway and I'm a partner here at our Troy office. Our July 2021 topics include, of course, the case law update. First, we'll talk about the Yang v. National Insurance Company opinion, then St. John and Medical Center v. Nationwide, then Harman v. Ewing, and lastly, Petersb Auto Club Insurance. As for the trending topics in PIP litigation, we will finish off with the opinion of Michigan Institute of Pain and Headache v. State Farm Mutual Automobile Insurance Company. As just a forward, the Petersb Auto Insurance Company and the Michigan Institute of Pain and Headache v. State Farm cases kind of coincide together and discuss very similar topics. First up, Yang v. Everest National Insurance Company. This case will be published. As of right now, it is an unpublished opinion in the process of being published. Pursuant to MCL 500-30201B of the Insurance Code, it is not allowed for an insurance company to cancel an insurance policy when the insurance company mails its customer a letter purporting to be a notice of cancellation for non-payment of premiums. This is not allowed before any non-payment actually occurs. A notice of, pursuant to the common law definition, a notice of cancellation must be peremptory, explicit, and unconditional. In the case of Yang v. Everest, Wesley Yang and his wife bought a 6-month no-fault insurance policy from Everest that was effective September 26, 2017 through March 26, 2018. Of course, the policy required that Yang pay a monthly premium and provided that the policy would be canceled during the policy period by Everest sending at least 10 days notice by first-class mail if the cancellation was for non-payment of the premium. On October 9, 2017, Everest mailed Yang a bill for the second monthly payment, stating that if Yang failed to pay the amount that was due by October 26, 2017, the policy would be canceled effective October 27, 2017. It's important to note that at the time the cancellation was mailed, Mr. Yang paid all of the applicable premiums. The letter also provided that the cancellation notice did not apply if Yang paid the premium on time. Yang did not pay the premium on time, and Everest terminated the policy for non-payment on October 27, 2017. On October 30, 2017, Everest then sent Yang an offer to reinstate, explaining that the policy was indeed canceled on October 27, 2017. It also noted that Yang could reinstate the policy with a lapse in coverage if he made the premium payment by November 27, 2017. At that time, Yang didn't make any payments to reinstate the policy. Thereafter, on November 15, 2017, Yang and his wife were involved in a motor vehicle accident. Specifically, they were pedestrians crossing a street when they were struck by a motorist. 2 days later, on November 17, 2017, Yang sent in the monthly premium to Everest. The policy was then reinstated effective that day, and the notice informed Yang that there had been a lapse in coverage from October 27, 2017 through November 17, 2017. Again, the motor vehicle v. pedestrian accident was November 15, 2017, so 2 days before the policy was reinstated. Yang then filed a claim for PIP benefits through Everest. Everest denied the claim, saying that Yang did not have coverage when the accident occurred, and then Yang and his wife sued Everest. At the trial court, Everest moved for summary disposition, arguing that plaintiffs were not entitled to benefits under the policy because it had been canceled and was not in effect at the time of the accident. Everest also argued that the policy's cancellation provision was not inconsistent with MCL 500-3021B. The trial court thereafter denied Everest's motion and granted summary disposition in favor of the motorist, who was added as a defendant as well. The court reasoned that Everest's notice of cancellation was not valid because it was sent before non-payment had occurred. and that Everest was therefore responsible for payment of Yang's PIP benefits. Everest then appealed, and the Court of Appeals also affirmed the trial court's order, concluding that the cancellation was not valid because Everest sent the notice to Yang before the premium was due, and the notice did not satisfy the terms of plaintiff's no-fault policy itself. The Supreme Court ordered and heard oral argument on whether to grant Everest's application for leave to appeal or to take other action. Under MCL 500-3021B, a policy for motor vehicle coverage may not be delivered in Michigan by an insurer for which premium or advance assessment is charged unless the policy provides that it may be canceled at any time by the insurer, mailing to the insured not less than 10 days written notice of cancellation. The phrase notice of cancellation has a peculiar and appropriate meaning in the law as reflected by the Supreme Court's decision in the case of American Fidelity v. R.L. Ginsburg and Sons, and Beaumont v. Commercial Casualty Insurance Company. Those decisions held that a notice of cancellation must be preemptory, explicit, and unconditional to be effective. Because there's no evidence that the legislator intended to stray from the common law meaning of this phrase when it enacted MCL 500-3021B, the common law definition of the phrase still applies. Therefore, a notice of cancellation must be preemptory, explicit, and unconditional to be effective. In the case of Yang v. Everest, the Everest October 9, 2017 letter to the plaintiff was ineffective for purposes of MCL 500-3020 because it provided that cancellation was conditioned upon Yang's failure to pay his premium. In other words, because the notice was not preemptory, not explicit, and not unconditional, it was not a valid cancellation notice. Thus, Everest was responsible for payment of Yang's PIP benefits. Next up, we have the case of St. John and Medical Center et al., the Nationwide Mutual Fire Insurance Company and Homeowners Insurance Company. This is an unpublished opinion that was issued June 10, 2021. This case centers upon the way to properly transfer legal title of a vehicle from one individual to another during a sale of the vehicle. Pursuant to MCL 257.240, to properly effectuate transfer of a title, the safest option is to make sure that the buyer signs the assignment of title and accompanies the buyer to a Secretary of State branch to assure that the title of the vehicle being sold is properly transferred. To further ensure that the title was properly transferred, the seller should maintain all relevant documentation of the transfer. The relevant facts in this case are that Sylvia Guzman purchased a Jeep Cherokee and acquired no-fault insurance through her insurer Homeowners. Later that year, she sold her vehicle to Eduardo Martinez. Martinez then became the owner of the vehicle when he took possession of it and left with the title. Martinez did not apply for title of the vehicle to Secretary of State, nor did he acquire no-fault coverage. Guzman allowed the homeowner's policy to lapse on the vehicle. 1 year later, Claudia Avella and Martinez were involved in a collision while occupying the vehicle. Avella suffered injuries and was taken to St. John Hospital for treatment. St. John Hospital sought to have her expenses assigned to an insurer through the Michigan Assigned Claims Plan, but due to a delay in the assignment, Nationwide paid benefits and was dismissed. They then filed a cross-complaint against Homeowners Insurance Company, alleging that Guzman did not properly assign legal title of the vehicle to Martinez, and she was therefore the proper owner. As a result, Nationwide argued that Homeowners was the highest order of priority for Avella. At trial, the jury was presented with two questions. One, whether Martinez signed the assignment of title before the collision took place, and two, whether Guzman complied with MCL 257-240, the statute that indicates how to properly transfer title. At trial, the jury found that Martinez signed the assignment for title before the collision occurred, but did not comply with MCL 257-240. Therefore, the trial court entered a judgment in favor of Nationwide, maintaining that Homeowners was highest in priority. The question on appeal was whether Homeowners, the insurer for Guzman, or Nationwide, the assignee for MACP, is the highest order of priority for the collision involving the Jeep Cherokee. Since this accident occurred pre-reform, Homeowners could only be in the order of priority if it were determined that Guzman was the owner of the vehicle on the date of loss. To determine whether Guzman held legal title to the Jeep on the date of loss, the trial court turned to MCL 2500-233, Section 9, which provides that an effective date of transfer of title or interest in the vehicle is the date of the signature on either the application for title or the assignment of certificate of title by the purchaser, transferee, or assignee. Nationwide argued that even if Guzman and Martinez complied with MCL 257233, Section 9, they also needed to satisfy MCL 257240 to effectively transfer the title. Pursuant to MCL 257240, Section 1 and Section 2, Nationwide argued that Guzman had to either accompany Martinez to the Secretary of State or maintain proof of transfer of the vehicle for approximately 18 months. The jury ultimately found that the parties did not do either, and Guzman was presumed to be the owner of the vehicle, making homeowners insurance the highest order of priority. So again, in order to effectively transfer title of a car when it is being sold, the safest option is to make sure the buyer signs the assignment of the title and then accompanies the buyer to a Secretary of State branch to assure that the title of the vehicle is being sold and properly transferred. Then the buyer should also maintain all relevant documentation of the transfer. Next up, we have the case of Harman v. Ewing, issued June 10, 2021. This is, of course, an unpublished opinion. However, it provides further evidence to support the general McCormick motions that defendants file. This case affirmed that a plaintiff must present some form of objective evidence, an X-ray, MRI, CT scan, to show an objectively manifested impairment. Diagnoses and restrictions alone are not enough to satisfy the first prong of McCormick. By way of background, defendant's motion for summary disposition based on a lack of suffering a threshold injury was granted. This litigation stemmed from a bodily injury suit brought by defendants Thomas Ewing, Thomas Mason, and Julia Everett. They'll be referred to as defendants hereafter. Plaintiff was a passenger in one of the defendant's vehicles, which ran into the back of another vehicle, which subsequently ran into another vehicle. Plaintiff admitted that she told the police she was not injured, and over the next couple weeks, plaintiff underwent CT scans, which failed to reveal any physical injuries or acute processes to explain plaintiff's complaints. 2 months after the accident, plaintiff moved to Georgia to attend a cosmetology program. While in Georgia, she treated with a chiropractor, and then there was a 7-month gap before she returned to the chiropractor. About a year after the subject incident, her chiropractor disabled her for injuries for her neck and back, but did also state that her condition had improved greatly. Almost 2 years after the subject accident, plaintiff underwent X-rays, which were completely unremarkable. Just over a year after the subject accident, plaintiff underwent an IME, which confirmed injuries to her neck and back, but opined that the treatment plan was not reasonable for a sprain or strain, which occurred more than 1 year prior in the accident. The IME doctor noted that plaintiff did not complain of any pain for 3 months post-loss, and her injuries were long healed at the time of the IME. During her deposition, plaintiff admitted that the hospital did not impact her education. She also testified that she only missed 2 days of work, and her headaches and pain restricted her from several activities. After her deposition, defendants moved for summary disposition, claiming that plaintiff did not suffer a threshold injury, as she neither suffered a serious injury nor was there any impact on her ability to lead her normal life. The trial court concluded that plaintiff had failed to meet the 2 of the 3-pronged McCormick test. Plaintiff failed to present any evidence of an objectively manifested impairment and also failed to show any impairment impacting her ability to lead her normal life. As we all know, to show a serious impairment of bodily function, a plaintiff must satisfy 3 prongs. 1, an objectively manifested impairment. 2, of an important bodily function. That 3, affects a person's general ability to lead his or her normal life. Regarding the first prong, the court held that the defendants had shown through medical records and the IME report that there were no objective findings to support plaintiff's subjective complaints. While plaintiff claimed that her hospital records showed she suffered injuries, the court determined that they did not show an objective manifestation impairment. The court also disregarded plaintiff's disability certificate, holding that these did not provide a diagnosis or a physical basis for plaintiff's pain, but rather showed that restrictions were premised on plaintiff's subjective complaints. Further, the court also found that plaintiff's chiropractic diagnosis and records showing limitations were also based on her subjective complaints. Ultimately, the court upheld the trial court's granting of defendant's motion for summary disposition, concluding that the plaintiff failed to meet present sufficient evidence that she suffered an objectively manifested impairment. Again, this case somewhat affirms or provides additional evidence of the typical McCormick lack of impairment motions that we typically file. This is a good one because it is very clean cut, and it specifically states that plaintiff has subjective injuries. So it's not stating that plaintiff need not have any injuries, but her injuries must have an objective manifestation. So this is very helpful in cases where plaintiff does complain of neck or back injuries, but there are not any supporting documentation to support those subjective complaints. Next up, we have the Petersb Auto Club Insurance Association and Halick case, which was issued on June 10, 2021 as well. The next two cases centered around a practice that is typically called balance billing. In this case, the Court of Appeals affirmed that an expense is incurred by the claimant under the No Fault Act when the claimant accepts treatment from a provider. This is true even if the medical provider expects payment from the insurer rather than the claimant, and thus a no-fault insurer cannot dodge its obligation of payment when the provider does not bill the claimant directly. By way of background, Plaintiff Peters was injured in an automobile accident and applied for no-fault benefits through Auto Club. She subsequently filed suit against Auto Club for unpaid PIP benefits following a motor vehicle accident. She sought treatment from Insight Physical Therapy and Neuro Rehab Center. Insight submitted a billing statement showing Medicaid payments of approximately $1,376 and insurance payments of $83,855 and a patient balance of what is essentially zero. Plaintiff was not billed directly by Insight. Auto Club filed a motion for partial summary disposition for Insight's expenses, arguing that they had not been incurred by plaintiff under the No Fault Act because Insight was not seeking payment directly from plaintiff. Furthermore, charges incurred were limited to the reduced amount accepted by Insight from Medicaid as payment in full. The trial court agreed that because plaintiff was not obligated to pay the Insight bill, the charges were not incurred and Auto Club was not required to pay. Plaintiff thereafter appealed. On appeal, plaintiff argued that Auto Club failed to prove that Insight did not incur the unpaid expenses or that it accepted Medicaid's payment as payments in full. A no-fault insurer is only required to provide personal protection insurance benefits for allowable expenses incurred pursuant to MCL 500-3107, 1A. The Court of Appeals noted that an expense is incurred under the No Fault Act when the claimant becomes liable to pay the expense, even if the insurer ultimately bears the burden of payment. Here, plaintiff became liable to pay Insight's medical bills when she accepted the treatment. Plaintiff's contract with the insurer to pay medical benefits on plaintiff's behalf did not alter the fact that she was liable and obligated to pay those expenses. Auto Club presented only the Insight invoice showing the patient balance of zero in support of its motion for summary disposition. The Court of Appeals determined that that invoice did not prove that Insight did not expect the insurance balance for plaintiff's treatment. It also failed to prove that Insight accepted Medicaid's payment as payment in full. The invoice listed an insurance balance, and Insight expected to collect the balance from Auto Club. Thus, plaintiff incurred the charges because Auto Club had an obligation for payment. The Court of Appeals further found a question of material fact as to whether the invoice demonstrated that Insight accepted Medicaid's payment as payment in full. And sort of on the other end of the spectrum for a balance bill case, we have the case of Michigan Institute of Pain and Headaches v. State Farm Mutual Automobile Insurance Company. This is an unpublished opinion that was issued on June 24th, 2021. Here again, the Michigan Court of Appeals further defined the incurred requirement of the Michigan No-Fault Act pre-reform as it pertains to providers bringing forth claims for balance bills when those claims are based on an assignment of rights. By way of background, plaintiff Michigan Institute of Pain and Headaches, doing business as Metro Pain Clinic, provided medical treatment to the underlying insured for a period of months after an automobile accident. After every visit, the insured would execute an assignment of rights in favor of Metro Pain Clinic, and Metro Pain Clinic would submit its bills to the defendant insurer for payment under the No-Fault Act. The insurer issued partial payments to Metro Pain Clinic for those bills based on the insurer's assessment of reasonableness of the charges and the necessity of the treatment. Metro Pain Clinic filed suit for the balance of those bills based on assignment of rights that it had obtained from the insurer. Defendant then moved for partial summary disposition and argued that because the insured could not have sued the defendant for payment of the balance bills since he suffered no loss or damages as he was not sued for the bills himself, Metro Pain Clinic had no cause of action based on the assignment of rights. After all, Metro Pain Clinic only held rights held by the insured as it was his assignee. In response, plaintiff argued that the insured incurred the medical expenses once he accepted medical treatment and was thus liable for those expenses. The trial court granted summary disposition in favor of defendant based upon defendant's assignment of rights argument. Plaintiff then appealed that decision, and the Michigan Court of Appeals reversed and remanded, holding that plaintiff did have the legal right to pursue outstanding balance as the insured assignee. The court then relied on the Covenant v. State Farm Mutual Automobile Insurance Company opinion to conclude that the insured in the present case incurred the charges for healthcare services he received from plaintiff once those services were rendered, and thus the insured became liable for payment. The court went on to distinguish this scenario, a medical provider pursuing a balance bill based on an assignment, from the fact pattern in McGill v. Auto Insurance Company, which is the seminal case that we typically file the balance bill motions for summary disposition on. The case also discussed the Lamothe v. Auto Insurance Club Association case, which permits both of these were lawsuits filed by the insureds themselves seeking payment of bills that the medical providers themselves had accepted partial payments without a challenge. The Court of Appeals concluded that plaintiff had the right to pursue reasonable medical expenses to which the insured was entitled under the No-Fault Act, which were assigned to it by the insured, and plaintiff could challenge as an unreasonable defendant partial payments of plaintiff charges for its healthcare services. The court eventually reversed the decision to the trial court and remanded the case for further proceedings consistent with its opinion. So here we have a case that does not, well, in my opinion, does not limit the typical balance bill McGill motions for summary disposition unless it's a provider filing suit and not the insured. So in McGill, we have the insured filing suit for bills that were paid that had, and the providers had not essentially come after the insured for payments of those bills. In this case, Michigan Institute of Pain and Headache v. State Farm, the provider is filing suit. The provider itself is claiming the balance of the bills and not the insured. So ultimately, medical providers with an assignment of rights can challenge the unreasonableness of an insurance company's partial payment. Charges for healthcare services are incurred once those services are rendered, and thus the insured becomes liable for payment of those charges at that time. However, in cases like McGill, if the insurer agrees to defend and indemnify the insured, then you may have a stronger motion for summary disposition on McGill, as long as it's not the case of the provider challenging the reasonableness of the bill. Again, thank you for attending the July 2021 episode of My PIP Monthly. My name is Amber Rouse Holloway. Please feel free to contact me with any questions or concerns. Thank you.